Hutchinson. Okay, so we'll get started here. Hi, my name is Jim Russell. I'm the chairman of the committee. I'd like to introduce Doug Booth on my left, Steve Beasley and Dave Helwig as the committee members. The committee's functions are to set up the provisions of the Building Code Act, the statute of the province of Ontario. Its function is to hear appeals from orders to remedy issued by the property standards officers under the property standards bylaw passed by the corporation of the village of Point Edward. The committee is in effect a court of appeal. It hears evidence from the persons involved, can visit the site if warranted, and can confirm, amend, or quash an order made by this property standards officers. It also has the power to extend times for compliance. If any of the parties are not satisfied with the committee's decision, the decision can be appealed to a court of law. All decisions will be rendered in writing. Anyone requesting a copy of the decision should provide the secretary with the full name and their mailing. Committee's function is to interpret, apply the provisions of the property standards bylaw. The committee will administer an oath to all who provided evidence to it. The committee is sitting to hear an appeal. Its function is to decide on the evidence before it. So let's see. I got this in my, so I'm talking about what am I missing? Okay, introduction of appeal. So that's the page I'm missing. Introduction of appeal. The committee is sitting today to hear an appeal made on the property owned by the Collectus Point Edward Inc., located at 204 Michigan Avenue, right?
Yes, sir.
Okay. Property standard officer, I will now call on our property standards officer, Kelly Bedard, who will provide a review of the order, the relevant sections of the bylaw, and other applicable evidence. We would request that the presentation be limited to approximately 15 minutes. So Jim will give the oath.
Wish to swear. You swear the evidence you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Thank you.
You? Seat, please.
We're going to you, Kelly.
Good afternoon. My name is Kelly Bedard. I work for the County of Lambton as a property standards and bylaw enforcement officer. We service the village of Point Edward. This property at 204 Michigan Avenue, Point Edward. We have a previous order this year on the property, which was appealed and an extension granted. I received another complaint, another tenant in an upper apartment by saying that water was leaking into her apartment. Some of the previous order was complied with, not all. So I issued another order to the property owner, Prolificus Point Edward Inc. I did not bring my title search for the officers of the company. However, it is issued to the company listed through the MPAC. Now, we issued the property standards order, the second one on September 22nd, 2025, with a deadline of October 27th, 2025. That order is to remedy the continuous doors and window leak, the signs of mold, and the roof leaking. I've asked that a full assessment of the building be done by a professional structural engineer licensed in the province of Ontario. And the completion of an environmental assessment and air quality testing for the entire building. I did receive paperwork from NSPEC hired by the property owner. However, it speaks to the original complaint in the lower apartments. And they recommended further investigation along the wall through intrusive testing to examine for potential concealed mold growth. So based on that report, it doesn't appear that the first order was completely complied with. And obviously not, because I received a further complaint of leaking water.
Okay. Did you have anything else to add to that? No, okay. So cross-examination of the property standards officer, does the appellant wish to cross-examine the property standards officer? Okay, so, yeah, do we have to, swear
Would you like to
in?
be sworn in or affirm? You swear that the evidence you're about to give, this carry on when you actually do give evidence as well. The evidence you're about to give is the truth, whole truth, and nothing but the truth, so help you God. Yes, I do. You.
Just one thing before we start, I has to caution you that your right to cross-examine is limited to asking questions on evidence presented by the property standards officer. Okay. You will have the opportunity later if you have to have any evidence.
Yes, sir.
Okay.
You said the order wasn't complied with. My only question for you is what was not complied with?
The water ingress.
Right.
Because it happened again, so obviously whatever he did do originally didn't work, or
Okay.
he's missed something. And then based on NSPEC's report that was submitted, as I said, elevated moisture content was present along the base of the east wall on the bedroom and adjoining closet. And I think I was quite clear originally that the wall needed, the plaster had to come out. It wasn't sufficient to just clean it and paint over it, which appears to be the work that was done. And spec mentions that further investigation is recommended along this wall through intrusive testing to examine for potential concealed mold growth. So my original request obviously wasn't complied with. They painted over it without investigating further by cutting out the plaster, the drywall.
The report you're reading, what's the date? Is this the report you're reading from? I'm showing her the report I believe she's reading.
Okay.
I will provide a copy to that.
Yes.
Can you read me for the tribunal? My apologies, committee, court. Can you read me the last paragraph of page 3?
In the absence of elevated spore counts and species suggestive of the proliferation of fungal amplification, no other recommendations are put forth at this time.
Can you skip up 2 paragraphs and read me that paragraph beginning with the word documented? Or the entire paragraph as you will? Maybe the entire paragraph beginning with the word the.
This one here.
Yeah.
It's up on the
Yes.
screen.
The overall concentration of spores inside 202 well within otherwise normal limits based on our experience in similar settings. Their concentration when compared to the outdoor sample was much lower. Generally, the species found in both samples are some of the most commonly found species both indoors and outdoors as well throughout the year. Most of the species present are documented Are documented as common allergens. No species were present which are suggestive of wet building material or building material that has been wet repeatedly over time.
And for the record, who is inspector? Is that a company that the committee would?
Yes, yes,
Okay.
we've used them before as well.
I have no more questions at this time.
Okay.
Ability to recall as needed.
Okay, yeah,
Thank you.
thanks. Does the property standards officer wish to cross-examine the appellant?
But
Sorry?
this is just, that's later on.
Oh, this is later
Like
on.
he has
Okay.
an opportunity to give.
Oh, right here. Okay.
So, yep.
I'd like to call the appellant a representative.
Okay.
We already did.
Yep.
Okay. Okay, just learning how to do this.
Hey, I mean, since last time I was here, you guys studied. I
I would like now to call on the appellant or a representative. I request that your presentation be limited to about 15 minutes. However, the committee will permit some flexibility to this guideline, provided the comments are not repetitions and are pertaining to the issue of the appeal. Issue of the appeal.
I have some documents. My apologies. We were late last night before we got these together. Mostly, I'm going to make a few quick points, but I do want to provide you with copies of my material. Is that
Fair enough.
acceptable?
Fair enough.
And I'll provide you with one.
Here, just pass them down.
There are 4 copies for the panel. And there are 2 copies of evidence submissions for the panel.
It's okay, I'll share with you.
Yeah, we can share. So. We both had our show.
Sure. Value playing well with others.
In front of you is a legal submissions document. My firm and the appellant's take on the matter is in here. I'm not gonna go ahead and read it point by point. You have it in front of you. I'm gonna highlight particular points for consideration. Is that acceptable? I don't want to take too much of your time.
Yeah, as long as it refers to what we're talking about, sure.
Yeah,
Okay.
absolutely. And my apologies, we were late in the night last night before we had this done. That's my fault. I should have had this in earlier.
Fine, fair enough.
One of our initial issues with this is in paragraph 1 of the burden of proof document in the legal submissions. Prior to issuing an order, the bylaw officer should be conducting an investigation and should be satisfied beyond a reasonable doubt, as there are quasi-criminal offenses and provincial act offenses violations that are standard with this kind of thing. The repeated property standard things I can't really find in provincial law. Certainly she's within her right to do that, and I'm not. Bear in mind, my job here is representation, so please don't think anything I'm saying is negative. Words, ma'am. Before ordering an engineering report, there would have to be some sort of factual evidence to suggest that an engineering report is necessary. And in fact, I'll present you in a few minutes with some at least compelling evidence that proves that it seems to be out of pocket. The investigation and the evidence that would have had to have been done in order to issue an order that is worth, I don't know, $200,000 should have been disclosed to our office or the appellant. It's standard procedure to know what you're relying on, to know what evidence you're relying on, to know who told you that was okay. Certainly, and without being rude, we haven't received any photographs. We haven't received any copies of any complaints. The orders are up for interpretation a bit. And again, I'm not making fun of anybody. I'm defending my client. Fair? Okay.
She'll have her opportunity, so go ahead.
Absolutely, yes. If there was an inspection, there are some points of law that I'm gonna go over. I feel like the way that it's being done from a legal standpoint, it's charter, it's almost charter infringing. My submissions are there. I won't make them on point today. Because of the nature of the order being so entirely thoroughly, I mean, that's an expensive order inside of a few pages. it's an expensive order without, and I'm trying to be as brief as possible, Mr. Chair, members. It's an expensive order without a contractor, a mold inspector, a engineer, or anybody. I mean, a structural analysis of this could be thoroughly expensive. It is a violation of fundamental justice to compel an individual to essentially pay for and provide an investigation against themselves. What we're being asked to do is perform hundreds of thousands of dollars worth of work and inspections without any rational building code or legal basis for them. Now, bear in mind, I understand that there were complaints and those have to be addressed, and that's certainly within the purview. But this is, it seems like as if it's gotten out of pocket, or out of hand rather. It's dipped so far into something that is almost court worthy that I just wonder if this is proper. Again, and I'm restating, and I'll be brief about it, but there is no construction basis or engineering basis or mold basis that says this needs to be done. And in fact, in a moment, I'm going to go to my next set of submissions, and I'll show you that he has fixed the roof, he's fixed the windows, the mold is not an issue. I will leave that as far as my legal submissions with you for review, because I understand you're going to issue an order in writing, correct? Okay, and to save your time, I'm going to move on to the second document in the brief. Not that one, sir. The second document underneath legal submissions. It's called backroll and timeline submissions. And I'll brush over this point by point. After extensive work on the property manager's part to sort contractors to comply with this order and the first order, the best case timeline, because the panel today decided not to quash. The best case timeline for the required repairs is late spring if the order remains as is. Now, my office did some independent review of that with contractors that we use as expert witnesses, and they think that that's super nice, and perhaps unrealistic. The structural analysis being some time, given scheduling for the same, leading to a completion date of around April, May, and I'm referencing an email in the second document you have beginning with a Gmail email is an evidentiary submission. I'm referencing page 1 of that evidentiary submission, where it gives a timeline for it. The roof replacement, and again, a roofer didn't look at it, a structural engineer didn't look at it. I find it hard to believe that a roof replacement is proper. But if a roof replacement is ordered, it has around the same deadline. I mean, we've all worked on our own homes, so you can't do it in the middle of winter. Since the first order, the following has occurred. The order set out two required actions. Number 1 was windows and doors. I've submitted a copy of the first order, but the committee probably already has it. It's at 11. The windows and doors were replaced or sealed to prevent water ingress. The cost of that work was roughly $4,000. 2 of the sliding doors in 2 of the subject units were replaced as simple maintenance as well. The other substantive issue on the first order was the repair of the intercom system. The entire building has been rewired. An additional phone line was added, and there is a working intercom system in the building. Following that, there was an additional request received during the amended decision that he wasn't aware of, and it was testing for mold. Pages 14 to 15 and page 19 of the evidentiary document show you the results of the mold testing. And I'll reference those real quick.
Yeah.
14, 15, and 19. In the letter from NSPEC, as Madam read earlier, it says in its end submission in the very last paragraph, in the absence of elevated spore counts and species suggestive of the proliferation of fungal amplification, there are no other recommendations are put forward at this time. Now it goes through an analysis of what's contained in there, and certainly if you don't can read it, but it's essentially You know, the same thing you'd find in an older house or a garage. It wasn't a mold. It wasn't something that was gonna make somebody sick. On page 19,
Is that, you said it wasn't something that made somebody sick? Is that your analysis of it or?
No, that's theirs.
That's theirs, okay.
now that, and look, you want me to reference that? I think Madam read it earlier. The overall concentrations, and I'm on page 2 of that report, which is page. My apologies, my assistant printed this without page number 40. Which is, it's page 2, it's page 14 of the report. It has the inspect logo on it and begins with observations highlighted.
Okay.
Molds are present everywhere, both indoors and outdoors. Individual susceptibilities and health effects vary greatly based on exposure to mold spores. Federal and provincial regulatory authorities have concluded it is not possible to develop exposure thresholds to date. Presently, there are no safe or unsafe exposure levels. Instead, authorities have determined that mold growth should be prevented in buildings and the risk of exposure should be minimized. The overall concentration of spores inside Unit 202 was well within otherwise normal limits based on experience in similar settings. The concentration, when compared to the outdoor samples, was much lower. Generally, the species found in both samples are some of the most commonly found species, both indoors and outdoors, as well as throughout the year. Most of the species present are documented as common allergens. No species was present which are suggestive of a wet building material or building material that has been wet repeatedly over time. At page 19, that report seems to suggest that as far as the mold testing that was ordered in the amended order, he thoroughly complied with it as quickly as he possibly could. On page 19, on the same day that NSPEC was there, someone from PuroClean, the way I understand it, was also there. They also issued a report. You have it at page 19 of your evidentiary submissions. It reads, the infrared imaging was consistent with what one would consider normal for a building of its age and construction. The humidity level were also showing normal levels for the time of year and the levels outside that day on the 12th of September. And to be fair, the next paragraph reads, the moisture meter did, however, find some elevated moisture readings along the east wall at the baseboard height. I would advise in further investigation, more invasive in those areas only, to rule out any mold inside the wall cavity. Back to the other document. So as you can see, he complied with your first order. The first order, however, ties into the second order, and I'll go through that briefly. Doors and window leaks, as we talked about above or earlier, and shown in the photos that you have, exterior sealing was applied to all windows and doors to prevent ingress, and we have pictures of that. That would be pages 27 to 41 of evidentiary submissions. As to signs of mold, as we've just read, the professional report said that it was within normal levels. The recommendation as follow-up for that was that it look at the area along the baseboard height. As to the roof leak. Sorry, sir.
Yeah, that's good. That's cheaper.
I gave you.
Which-
Oh, I found that in. Go ahead, sorry, didn't mean to interrupt.
No problem, sir. Thank you. The roof was repaired on September 10th, specifically to address leaks during heavy rainfall in the point here. Since that repair, the unit's dry, it has no visible signs of further leakage. Order number 2 asks for a full assessment of the building by a professional structural engineer licensed in Ontario. The order is not clear as to why a full structural assessment of the building would be required. But however, we requested quotes from structural engineers. One firm noted, it's at the bottom of page 1 of the evidentiary submissions, and I'm quoting it. Based on our review of the county order, I don't see any references to a structural concern of the roof that would necessitate a full structural assessment. I just want to confirm if a structural assessment is what's needed currently. That raises a legitimate question about the necessity and scope of a full structural assessment in the absence of a specific structural concern denoted in the order or in evidence. Completion of, number 5, completion of environmental assessment and air quality testing. We went over that at length. It's been done and the recommendations were followed. Windows and doors were sealed and repaired. The costing for that was upwards of 6,000-7,000 or something. As noted above, the roof was repaired on September 10th to address leaks observed during a heavy rainfall the previous day. Since that repair, the units remain dry, the buildings remain dry, and there's been no further leaks. It's to the best of my knowledge, there's also been no leaks to the home, the property owner or the property management company. If what the panel decides on today is following through on the order as is, the property owner would respectfully request mid to late March, assuming weather cooperates to fulfill that sweeping of an order. A more realistic timing from contractors is when temperatures are stable and snow and excess water are not compromising the quality of exterior or structural work. Spring. I wanted to add one more point. The building is currently sold, pending the outcome of the order. The last page of your evidentiary submissions is this section that I'm legally allowed to give you regarding the closure. It's the signing page. You'll recognize it as a common purchase agreement. I would suggest that the order and the subsequent order have been substantially complied with at every point where the order is in fact legally sound. We respectfully request the following. The order and the subsequent order, given the evidence in front of you, are complete. That the order be marked as such and the city close both, resolving the matter in finality, allowing the sale to move forward. Number 2, in the alternative, an inspection that meets lawful criteria be performed and the committee reconvene to assess the timing for completion of same. Or in the further alternative, a meaningful, realistic timeline agreed upon that would allow completion of the work requested. And the same is not overburdensome either financially or timing wise. This isn't a slump. It's not, you know, I think you're hearing complaints about it. But this isn't, I mean, to drive by the building, to look at the building, this isn't a dump. It's not like you have a slumlord running a property in your area. He's complied with the order. He's provided you evidence that he's complied with the order. The request for a structural engineer and a full roof replacement is, with apologies to the committee, just absurd. Without some sort of logistical or engineering background or construction background behind it, it doesn't make sense. Those are my submissions, sir.
Okay, thank you very much.
Yes, sir. Did I get that quick enough?
You did very well, thank you. Okay, so cross-examination. Does the property standards officer wish to cross-examine the opponent? Yeah, that's fine. Just keep the questioning in evidence presented by the appellant, that's all. Yeah, it's okay.
So I'm not gonna go too far into your first page there with the burden of proof. I am certified by the province of Ontario. Ontario Association for Property Standards Officers, and been doing this for 16 years. We look at a property, and because I am not an expert, I am not an engineer, I am not a building inspector. We issue the order based on what we're seeing.
Objection. Is there a question in the future? She's cross-examining.
Just like we did, just keep it to what he was referring to.
Yeah. So I need to ask you about where this information came from on your burden of proof, because some of it really isn't accurate. So we issued the order, hence why I'm asking for an engineer to make comment. And not just, so can you tell me who Austin is? Austin Robinson.
Ma'am, what are you referring to? My apologies.
That's okay, he's on all these.
We look at the evidence, the thick packet.
Yes. With emails on top.
So he's the maintenance manager for Guardian Real Estate.
So do you happen to know what his credentials may be?
No, I don't.
Okay, cause he makes comment in here as if. He is more in agreement with. The order of the extension, he's not really saying,
Is there a question in the future? I'm sorry, objection.
so I have to clarify what you have presented. So that's what I'm trying to do, I'm trying to clarify what you have presented already. So the building is sold, does the new property owner know that these orders go with the property? Are they aware of that?
I'm not a real estate lawyer.
Okay. That's it.
Okay. Thank you. Any other questions?
I think we have to. What do we?
Here, from here, yeah, I know it's
Yep.
here, but anything
Yep.
else? Just want to make sure I'm not going online.
No.
Okay. Are there any questions from the committee members to clarify any of the evidence that has been?
Questions?
Does anybody have any questions at all?
I have a question.
Good.
The repair to the roof, you conclude that the repairs and the leaks are 100% fixed.
Yes,
Is that based on
observation.
the fact that there's no complaints, or you've been in the building during a rainstorm and witnessed nothing?
I'm a law firm, in council. I have not been in the building. The property management company's been in the building, and there's been no more complaints of the roof leaking to them or the owner. And they have checked on it. I know that there was a series of communications where my client was instructing them to check on it. And they were checking on it to make sure that there was no longer an issue.
Okay. Does the property management company work on behalf of the owner then? Would it be fair to say they're not truly impartial, or are they?
Yeah, I suppose that's a fair assessment. I guess it depends on whether or not they like to keep their job.
Mhm.
Yeah,
Are any one of the rooms that we're referring to here still inhabited, or are they like uninhabited at this time?
no, that unit in particular, and it's not here, so I don't want to comment on it too long. I know that the person moved out of that unit.
So is there anybody,
That person did not file any landlord and tenant board court proceedings thus far. I'm counsel for the corporation. I would have known.
Right.
And I know that the property management company wants to redo the flooring in the unit, and there is an email where they were asking permission.
so is it fair to say that the person who made the complaints is no longer able to make complaints because they're not there to do so?
Fair, yeah,
Okay.
fair.
Okay, that's all I have.
Thanks, Doug.
But for the record, the building does have other tenants that
Okay.
could make
But
complaints.
that have
Yeah,
never made complaints prior to or subsequent.
That's my understanding, yes.
Picture.
I did receive a new complaint. From a new tenant, not in that original.
Definitely you.
Objection. I know I'm witnessing right now, but I'm also counsel, so apologies.
Yeah.
Contains facts, not in evidence. There is no proof of that.
Okay. Point taken. Okay. Dave?
No, go ahead.
Yeah, well, would that complaint have been made to the property management company? That was one of my questions. Have there, subsequent to these work orders, have there been any other complaints?
To the best of my knowledge, no, there have not been. And he would have told me. I'm not aware of any.
And that would be,
And I am aware of an ongoing presence from the property management company's maintenance people in that building, fixing up and repairing things.
would that be Austin?
I believe that's the guy that works for Guardian, right?
Yes.
Yes.
Okay.
I think you guys asked my questions. Any other questions? No? Okay. So there being nothing further, the committee will now retire.
You guys don't look that old.
That's
Okay.
We're on. to make the decision. If you wish, you can wait for an oral decision, or you're welcome to do so, or I expect it's gonna take us a little bit of time for us to discuss all this, so get that back to you in writing.
Want to issue in writing?
We can issue.
Yeah,
it,
well,
right?
yeah.
Okay. May I make a final submission?
Yeah, just keep it brief.
Yes, sir. May I stand?
Sure, yeah, you guys-
Just not used to sitting when I'm arguing. Before you, number one, you have substantial compliance, documented, on the first order. He came here, he asked you for more time to complete it. You have the evidence of his completion in front of it. Number two, with respect to the lady, and understanding her credentials and her job for the city and having respect for it. A structural engineer and a structural analysis on a building that's standing and has no issues seems overreaching. Respectfully ask that you quash that you consider the first order closed. That the second order be quashed because it largely contains items that were corrected and you have proof in front of you of inside of the first order, or that in the alternative, you allow the man some adequate time to work on a limited scope of repairs. Or in the further alternative, and I forgot what the further alternative is, my apologies.
Realistic timeline, am I right?
Yeah, thank you, sir. I believe it's the last page of factual timeline. The order, the subsequent order are complete, marked as such, and the city should close both for resolving the matter in finality. In the alternative, an inspection that meets criteria be performed and the committee reconvene to assess the timing. Or in the further alternative, a meaningful, realistic timeline. And I'm authorized to enter into that. So decide.
Very good, thank you.
Thank you, guys. Appreciate it.
Property standards officer, would you like to comment on that this time? Give you a few minutes.
Nothing really other than I disagree that it's fully compliant with
Okay,
as, and just for the record, we don't divulge who the complainant is. Complaints come through this office, or they come directly to me, and that's exactly what happened in this case. I think I submitted my email. That's all.
very good, thank you. So we're gonna call this to an end, and we'll meet, so we're, at this point, we're going to adjourn this meeting. Okay, do I need a seconder for this?
No, you can just declare it adjourned if you like.
Just declare it adjourned, okay,
Mhm.
thank you, we'll meet after this. Yep, thank
May I
you.
be excused?
You may be excused, Yes, thank you, thank you.